Hello and welcome back to another tutorial on media laws. This is Sushyata Sengupta Roy and I am from Swami Vivekananda Institute of Modern Science, Department of Media Science, and we'll be discussing about Intellectual Property Act. Now, when we talk about Intellectual Property Act, it is basically refers to materials which is depending on one's intellect. So IPR or the intellectual property rights are the legally recognized exclusive rights to creation of the mind. So whatever our mind creates. So intellectual property refers to creation of the mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. So it is an intangible asset. You cannot see, it's not your landed property. So why do we need to protect intellectual property? Why? Because intellectual property has a company value, it has an entry barrier, it is legal for its legal monopoly, to avoid free riding, to avoid infringement, for financial averaging, for advance of mankind, for goodwill, for counterfeiting, and for the work of art. So, agreement on trade-related aspect of intellectual property right is called the TRIPS. The trade-related aspect of intellectual property rights is called TRIPS. So, TRIPS is an international agreement administered by World Trade Organization or the WTO. So, negotiated at the end of the Urugari rounds of the General Agreement of Tariffs and Trade is the GATT Agreement of 1994. So there are around 158 countries who have became a member of this GATT Agreement of 1994. So what exactly do we mean by this intellectual property rights? So what are the places which is governed around this? So when you talk about intellectual property right, it's basically under whatever the rights are, it has to be under the Ministry of Commerce and Industry, Department of Industry, Policy and Promotion. So under that, when this Commerce and Industry, the Department of Policy and Promotion, it comes in. Under this, there are four offices: the Patent Office, the Trademark Registry Office, the Geographical Indicatives Registry Office, and the Patent Information System. So these four basically safeguard the intellectual property when we talk about. So because you cannot copyright intellectual property, it comes under the Human Resource Ministry. So when we talk about the intellectual property, these are the four offices which are the four acts which are absolutely important to discuss. So what is the Patent Act of 1970? The Patent Act of 1970, which is one of the safeguards of the intellectual property. So when we talk about the intellectual property rights, the first thing which comes in is a Patent Act of 1970 by which we can safeguard our intellectual property. So for granting the patent, following conditions are essential. What are those? The novelty, non-obviousness, utility, and endowment. So prior act, public domain or public use. So prior art, something which is already known to mankind, which is already known to people. So one cannot patent on things which is already known to people. So you can patent on something which people doesn't know about, which is absolutely new to the market or people. It's something good for the people. So anything which is already known in general or to specific group of person, whether in the same country or abroad, cannot be patented. So that's an exemption as far the patent right is concerned. So when we talk about the patents, there are the application. Where is this patent right, or where is this patent applied? So first, inventor, assignee, legal representative can file an application. Anybody who is an inventor of a product can apply for a patent. So provisional specification to be attached with application. A complete specification shall be filed within 12 months from the date of filing of the application. Now, controller may ask for further details. Patent will be granted after complying all requirements. Term of 20 years from filing a patent application. Addition can be done in existing patent. So compulsory license, which is under section 84, and 3 years of granted patent. So under section 92A also. So government power is to use innovation for the purpose of government, that is under section 100. So when we talk about patent, we all know like there are things already patented, like Ravindra Sangeet is was patented. So like then once it is patented, it will not be able to be used by somebody else. So when we talk about the patent, so patent cooperation, treaty. So when you talk about the Patent Cooperation Treaty, the PCT is an international patent law treaty included in June 1970. It provides a unified procedure for filing patent application to protect inventions in each of its contracting states. So a patent application filed under the PCT, or which is the Public Cooperation Treaty, is called an international application or PCT application. Total around 148 parties of there can be there for a patent cooperation treaty. So we talk about the patent cooperation treaty, we have to understand that it's a unified procedure for filing the patents. Now let's talk about two companies absolutely known to us, like it's like everybody knows, Apple and Samsung Electronics. So there was a case between Apple and the Samsung Electronics. There was a dispute regarding design of smartphones and tablets, computers, which is way back in there, 2011. So by October 2011, litigations in 10 countries were filed for this. Apple won in US and lost in South Korea, Japan, UK, Germany, and Australia. So basically, where Apple won in US, Samsung won in other countries like South Korea, Japan, UK, Germany, and Australia, as per their design of the smartphone and tablet computer was concerned. But that's all about the patent about. So when we talk about patenting, one thing in India we are all known about, like Satyame Jayate was a program which was telecasted in television, and Amir Khan was the main anchor or the main host or the main Sutradhar, as we call it. But then what later we have come to know that Satyame Jayate was patented by Amir Khan, that nobody else will be able to produce or put upon any of the program with the same name, Satyame Jayate. That's the essence of Patent Act. So the next part of protecting our intellectual property, we are obviously, as we said, that we are discussing the intellectual property right. So the next the main the main guides or the main protector of the intellectual property right is the Copyright Act of 1957. So when we talk about the Copyright Act, the copyright can be given in the following. So where are the copyright being applicable? So copyright is not given to ideas but to expression of ideas. When we talk about copyright, it is not given to anybody who thinks anything cannot be copyrighted. My thinking cannot be copyrighted, but my thinking when expressed is I can apply for a copyright. So what are those? One, original literary, dramatic, musical or artistic work can have a copyright. A cinematograph film can be copyright. A sound recording can be copyright. So the application to be made to register of copyright at New Delhi. So terms of copyright is 60 years from the beginning of the calendar next year, following the 3 years in which the author dies. So in co-author death of last author, for other it is also 60 years. So compulsory license can be given under section 31 for copyright under the Copyright Act of 1957. Now, safeguarding the Intellectual Property Act, the third one or the third weapon is the trademark, which comes under the Trademark Act of 1999. The trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods and services of one person from those of others, and may include shape of goods, their packaging and combination of colors. So it may include shape, packaging and color combinations. This mark may be a logo, a symbol, a brand, a heading, a label, a name, a signature, a word, a letter. A well-known mark is not registered but being used for a long time and established itself as a strong brand. Protection is also available in the trademark law. It's valid for 10 years to be renewed. Now, Colgate. There was a day when mothers used to say, like, why don't you Colgate in the morning? Brushing means Colgate. That's the brand identified as. Now, Colgate is a brand under it's Palmolive Group. So now, when we talk about the Colgate, it's a brand by itself. So if you don't trademark on Colgate, everybody is going to produce some or the other toothpaste with Colgate Premium, Colgate H, Colgate M, or whatever. So a trademark is very, very important to safeguard the intellectual property again. The logo, the symbol, the brand, the heading, label, name, signature, word, or letter. So when there's like another safeguard of the intellectual property right, the fourth one is the designs, which comes from the Design Act of year 2000. Just 1 year after the trademark is the Designs Act, which is in the year 2000. So a design appeals solely to the eye. The eye must be the eye of the customer on a visual test. So there should not be any functional consideration. So 10 years validity of registration can be renewed for the second period for 5 years. Your designs absolutely can be patented, or your designs can be registered in your name under the Designs Act of year 2000. Now we'll come to the fifth portion of protecting your intellectual property right is the geographical indication, or which comes under the Geographical Indication of Goods Registration and Protection Act of 1999, same as the Trademark Act. So the geographical indication in relation to goods means an indication which identifies such goods as agricultural goods, natural goods, or manufactured goods. So as originating or manufactured in the territory of a country or a region or locality in that territory where a given quality, reputation, or other characteristics of such goods is essentially attributable to its geographical origin, and in case where such goods are manufactured goods, one of the activities of either the production or of processing of preparation of the goods concerned takes place in such territory, region, or locality as the case may be. Again, Geographical Indication of Goods Registration and Protection Act is valid for 10 years and can be renewed. So this will basically protect your products from territorial problems, like wherever it's originated from. So again, this will be protecting the intellectual property. Now, when we talk about the geographical location protection, so when we talk about the Geographical Indication of Goods Registration of and Protection Act of 1999, it has to be registered. Now, how? So now suppose we talk about the Darjeeling tree. First regional GI in India, Himachal Pradesh. Now we talk about the Mysore silk, which is from Karnataka. Kutch embroidery is from Gujarat. Feni is from Goa. Bikaneri bhujia is from Rajasthan. Tirupati laddu is from Andhra Pradesh. Nagpur orange is from Maharashtra. So on and so forth. Rasgulla is obviously from Bengal. So it's like registered. So as on September 2013, total 215 GIs has been registered. So what is the traditional knowledge? So the traditional knowledge is passed on from one generation to the next, mostly in oral form and sometimes in writing. So the knowledge comprises innovations, information, practices, customs, traditions, etc. So the knowledge may be with regards to the use of the natural resources, environment, plants and animals, curing diseases or nature in general. So most of knowledge is undocumented. So why? Because the traditional knowledge, as we know, some leading cases like basmati rice, neem controlling fungus in plants by using neem oil, turmeric for healthy wounds. So in US patent granted, India succeeded stating it is prior knowledge in India. So now if US trade, they patented on basmati rice or neem or turmeric, we would have lost its, the strength over it. So, but then India proved it that no, we had the knowledge about, neem or basmati or turmeric far before its prior knowledge. And I think we can find traces of this medicinal herbs in Susrut Ved. So it's like it's in Rig Veda. So it's absolutely the part is Susrut, but then it's very, very old one. So it was based on the knowledge base. Now, trade secret, confidential information, Every company does. I always give an example of KFC's chicken. Now when we talk about KFC's chicken, and if KFC's chicken was so easily to be made in at home, it would have lost its importance, its taste, and its sell rather, the marketability. So the three essential elements of trade secret and confidential information is the subject matter must be a secret capable of adding economic value. Like KFC chicken, it does add up a lot of economical value because it is not easy to be made. Or rather, you cannot get a copy of KFC chicken in any other food stores. So the owner must take reasonable precautions to keep it a secret. The purpose is to ensure that no one claims protection for something which was flowing freely in competitors like this. If KFC chicken was available with SFC chicken, with Arambag chicken, with Shaguna chicken, or maybe many other chicken would have tasted the same, then they could have never said that it is a trade secret or confidential information, because it's available for all. Like an egg roll or a chicken roll can be manufactured, can be made by any shop, any food station, but not KFC's chicken. So because it's different, so it's said like it's finger looking good. So the purpose is to ensure that no claims protection for something which was flowing freely in competitors. So in case of breach, the owner must prove that the competitor got the information in a wrongful manner. So as one of the leading cases we all know, like Diljit Tysis case, which Delhi-based lawyer and his associate cases. So how do we talk about the Protection of Plant Varieties and the Farmers' Rights Act of 2001? Now when we talk about farmers, do we really know that there are real people, real farmers who have done magic with plants? They have made different breeds, a new breed of plant which gives us more of fruits, maybe more of vegetables, maybe a better quality of vegetables. So their brains, their intellectual rights really has to be protected, and that can be protected under this act, which is the Protection of Plant Varieties and Farmers' Rights Act of 2001. So the breeding activities and exploitation of new variety are the decisive factors for improving rural income and their overall economic development. Since the process of plant breeding is long and expensive, it is important to provide an effective system of plant variety protection with an aim to encourage the development of new variety of plants for benefit of the society. Now, what is the farmer's rights? It's very important. So, farmer who has bred or developed a new variety shall be entitled for registration and other protection under the Protection of Plant Variety and Farmers' Rights Act of 2001 in the same manner as the breeder of a variety. So if you do something new, if you have add up something new for the society, you ought to be safeguarded by this Protection of Plant Variety and the Farmers' Rights Act of 2001. Now, duration of protection of the registered plant variety. The duration of plant variety is different from different crops. Like for trees and vines, it's 18 years. For other crops, it's 15 years. For extant varieties, like 15 years from the date of notification of that variety by the central government under Section 5 of the Seed Act of 1966. So, if somebody breeds a beautiful, variety of rice, or maybe a beautiful variety of something, some crop, he can be protected under this act for the next 15 years. And if it's a tree like a mango breeded with orange flavor mango, that will be protected for 18 years. So the last rule of the IPR, or the intellectual property right, is the cyber squatting. So as I have told you in my previous class with cyberspace or cybercrime, this is absolutely, the digital world has brought us these crimes and these acts and these squats. So because with the because of we are getting into a newer world of digitized version, we are getting into a newer world of digitized crime. So now we are talking about the cyber squatting. So using a domain name with bad faith intent to profit from the goodwill of a trademark belonging to someone else, the cyber squatting then offers to sell the domain to the person or company who owns a trademark contained within the name of the inflated price. So this is basically a cyber crime. Cyber squatting is a cyber crime. It is basically when it's like a domain name is being with a bad intent or to make profit from the goodwill is being floated with the same name. That's absolutely a cheating part. To know more about this cyber squatting, please refer to my another video which is on cyber crime. If you want, I can obviously put up the link in the description box so that you can click on the link and get to the cybercrime video. You'll find the cybercrime and the cyberspace. There are some other videos also where you can get a real description, an absolute description on this cyber squatting. So by this we complete the intellectual property right. It's our property, the property of the brains, and how to protect it by different acts and rules. So it is all for now, and please go through it once more. I don't think it will be tough. It's absolutely easy. That's all about intellectual property right. Thank you so much for listening. Stay best.